start. So, good morning, everyone, and welcome back to our weekly webinar series. Last week has been a happening one. Saturday, Sunday, there were two initiatives from IPA, IBBI in Bombay. Yesterday, we were in Delhi in another IBBI organized event, and we also have a host of updates in the regulations from IBBI last week, on which we plan to have a discussion today. So, let's start. Over to Anil, sir.
Yes, thank you, Ankit. And I am somehow getting some difficulty in this while I'm trying to share my screen also. But yes, I would be able to do that. I hope I'm able to share my screen.
Yeah, your screen is visible. You can just make it full screen PPT. That's
Yes, yes.
perfectly okay.
So, welcome to all the participants. This is our uh, the weekly webinar series, and the subject this time it is of obvious, very obvious subject that we have. 18th of September 2023. In fact, the three updates in the regulations were uh, announced by IBBI, and we would be doing our discussions on these updates only. The updates are primarily focused on the difficulties faced by the insolvency professionals, also kind of some of the responsibilities, some of the workload of the adjudicating authority is a kind of maybe reduced with some of the regulations coming in. Some of the processes which were not defined earlier are now being defined clearly. So let us understand what exactly is the IBBI means by this. So I think the first one that we are taking up is the regulation 2 capital D, where the IBBI has inserted a regulation 2D with the intent that some of the information which is required by the adjudicating authority should be part of the application. The issue of limitation, debt and default, and the limitation period, that is supposed to be inserted in the application form itself. The newly inserted regulation 2 capital D says that while filing an application under section 7 or 9, the financial creditor or the operational creditor, as the case may be, shall also submit along with evidences. Number one, chronology of the debt and default, all means all timings, when debt was taken, when default happened. Then the date when the debt became due, because see, in most of the cases there is a lot of adjudicating authority hearings are wasted only to ascertain what is the due date of the default, what is the due date of the debt. If the due date is not there, then it is very difficult whether the default was there or not, because there has to be a due date and then only the default. If there is no due date, there is no default, even if the money is not paid for 10 years. Then is the date of default. Then is the date of part payments, if any, in between, if some payments are made or some kind of one-time settlements are approached. Then the date of last acknowledgement of debt, because as per section 18 of the Limitation Act, the acknowledgement is very important. The Supreme Court has already said that the acknowledgement of debt can be by way of an offer for one-time settlement, by way of the carrying that debt in the audited balance sheet. So these are various, and any kind of acknowledgement given or any kind of email sent. So the acknowledgement is a very kind of a saving a situation for the limitation law. Then the date of acknowledgement of debt, and the last is the limitation applicable. So this entire process of defining the chronology, date of the debt becoming due, date of default, dates of part payment, dates of acknowledgement, and the limitation applicability will be part of the application. Even earlier, on 14th of June 2022, IBBI inserted some of the regulations, and those regulations were 2 capital B and 2 capital C. That was also, this 2 capital B was only inserted for operational creditor, and it was also very specifically mentioned in the regulations that the GST returns, GSTR1, GSTR3B, filed with the goods and services tax GST department, that also should be part of the application. And the copy of the e-bill wherever applicable. Now, of course, it is applicable to all those companies where the total annual turnover is more than 5 crores, but earlier it was something like 50 crores. Now, e-way bill, GSTR 1, GSTR 3B has to be part of the application as per the earlier inserted regulations 2B, and 2C also said that the permanent account number and the email ID also must be mentioned, because that is something which is required for service of the applications, so that the other party can represent and the time is saved. So the uh, earlier inserted regulation 2 capital C was applicable to section 9 and 7 both. However, 2B was applicable only to section 9. So in case we see the efforts of the IBBI, uh, 2B, 2C, and 2D, all this was basically, the intention was to save time of the adjudicating authority. The applicant should be very clear while making the application that this information is important, and the applicant should furnish all the details of the documents for all of this. So Ankit, this part is basically focused on reducing the timeline for acceptance of the applications under section 9 or 7. Yes,
Yeah,
Ankit.
and yesterday's message from Mr. Ravi Mittal, Chairman IBBI, was also very clear that okay, maybe NCLT is overburdened with applications, but what can we do to reduce the the time taken by the NCLT? So I think this is on the same lines that IBBI is now thinking on what can be the standardization, or what can be regular formats that can be made so that the applications are simpler and they have lesser questions. It takes lesser time to adjudicate the applications under 7 or 9. That's the idea.
Yes. So, and the other very important part where the adjudicating authority's time is consumed is application under section 19(2), or applications under regulation 30, or applications under section 68 and 70 of the IBC. Now, these three sections are being used for taking information, control, and custody from the corporate data. Now, let us we see in our conversation, we first of all let us understand what is corporate data. Now, this regulation 3A, which is inserted by the IBBI on 18th of September 2023, first of all say that the IRP or the RP shall take custody and control from. Now, the from is the personnel of the corporate debtor. So whenever we call personnel means key managerial personnels, and the key managerial personnels are defined under the Companies Act. Then is the promoters. Then is the any other person associated with the management of the corporate debtor. No, any other person associated with the management of the corporate debtor. So all managerial persons, all consultants, auditors, they are also covered under this regulation 3A. Even the auditors are otherwise covered. But in this particular scenario, even the consultants are also covered. So in our conversation, whenever we talk about corporate data, that the information is being sought, custody is being taken, control is being asked from corporate data. That means that we have to ask it from the key managerial personnel, including directors, including managing directors, including CEOs, including CFOs of the corporate data, promoters, and any other person. So corporate data means all these parties taken together becomes corporate data. So the information, control, custody can be given by any of them. So what exactly is required to be taken from them? So what is required to be taken from them is basically, first of all, it is provided in section 18, subsection A. The records of information relating to the assets, finances, and operations of the corporate debtor referred in clause A of section 18 for determining the financial position of the corporate debtor. This information includes and relating to business operations for the previous 2 years, financial and operational payments for the previous 2 years, list of assets and liabilities as on the initiation date, CIRP initiation date, such other matters as may be specified. This is what is mentioned in section 18A. Now, going to regulation 36 of the CIRP. Why we are going to regulation 36? I'll just come and on the next slide. I will explain that what we are saying is section 18A and then regulation 36. This is what is mentioned in the new regulations inserted on 18th September 2023. Now, what is required under regulation 36 of the CIRP regulation? All the information required for preparation of information memorandum. Now, the RP or the IRP has to seek information which is required for preparation of information memorandum. So I don't need to go through all the details which are required under Regulation 36, which this is also recently amended. The Regulation 36 was also recently amended. Now, the other thing say the assets recorded in the balance sheet of the corporate debtor or any other records referred in clause F of section 18. Now, what are these records? Now, the F clause F of section 18 says, take control and custody of any asset over which the corporate debtor has ownership rights as recorded in the balance sheet of the corporate debtor or with the information utility or with the depository of securities, NDS and NSDL, etc. Any other registry that records the ownership of the assets, like registrar of documents, registrar of trademark, registrar of vessels, registrar of motor vehicles. So all these ownership rights, if it is recorded other than balance sheets, so these are all becomes something that is required by the RP or the IRP for the purpose of preparation of information memorandum and for the purpose of operations and for the purpose of understanding the liabilities of the company. Now, so this section 18 clause F further says assets over which the corporate debtor has ownership rights which may be located in a foreign country, that is also included, and we have a right as an RP, we have a right to seek information about this. Assets that may or may not be in the possession of the corporate debtor, but it is owned by the corporate debtor. Tangible assets, whether movable or immovable. Intangible assets, including intellectual property. Securities, including shares held in any subsidiary of the corporate debtor, financial instruments, insurance policies. Assets subject to the determination of ownership by a court or authority. Now, let us understand that this particular scenario that we have seen, this is what is required. The regulation 2B says that the IRP shall take custody control of from the corporate debtor. Now, what we have to take from the corporate debtor is mentioned in section 18, clause A and clause F, and also in regulation 36 regarding information memorandum. That is what is required to be taken from the corporate debtor, including all these even disputed assets and disputed properties, all this. Now, let us understand these scenarios, because see, what is the scenario? Presently, we are filing an application under section 19.2, like seeking cooperation, seeking information, seeking control and custody from corporate debtor. We are also filing an application under regulation 30 of the CIRP regulation, where the district authorities, the local authorities can be directed by the adjudicating authority to provide help to the resolution professional for taking over control and custody. Then we go to regulation section 68. We go to section 70 and we file applications to NCLT that they are not cooperating. They have taken away the properties of the company. So the prosecution may be started. And our prayer is that the prosecution may be started. And in case there is an order from the adjudicating authority, yes, they have concealed the information. Yes, they have disturbed the CIRP. Yes, they have taken away the properties of the company. That kind of order will then finally be sent to IBBI under section 236 of the code, and then IBBI will start prosecution against the personals of the corporate debtor. Now, the process 19.2, regulation 30, section 68, section 70. So all this, however, all this basically is targeting at one thing, that the what has been given by the corporate debtor, what has not been given by the corporate debtor. There was no process defined in the code, there was no process defined in the regulations. So now the IBBI has defined a process, what has been given, what was sought, what is not yet given. so that all the process documents are now specified. What are the process documents? Now let us understand the scenario one. The scenario one is that to the extent the corporate debtor is cooperating. If the corporate debtor is cooperating, then a CD shall provide to the IRP or the RP while handing over custody, control, documents, information. The CD shall provide a list of assets and records while handing over their custody and control. That is the duty of the CD, the personals of the CD, the persons associated with the management, the promoters. Because see, I said that in this conversation we will only use corporate data. I have already defined what is corporate data when we seek information. So the first thing, in case they are cooperating, they are also now required to make a list. Then the IRP or the RP, after taking such custody and control, if deemed necessary, identify person in whose possession these assets and records will be. Now, why this particular clause? Now let us understand a situation that we have taken a control and custody. We've gone to the corporate debtor. The corporate debtor gave us a list of assets and records. The records may be accounting records, the records may be technical records, the records may be the trademark records, the record may be even operations records. Some of the record are original, some of the records are basically as a process documents. Now, the list of assets and records are handed over to RP by way of a list. Now, RP cannot take it home. Can the RP take all the cars at home? Can RP take all the trucks to home? Can the RP take all the machines to home? Can the RP take all the stocks to home? No. The RP will prepare a list that as on the date of commencement of CIRP, these were the assets, and the CD has handed over me a list of assets. In that list of assets, everything I verified from the physically I verified, then I handed over. I handed over the machines to the production manager. I handed over the overall assets of the company, operational assets of the company, to the managing director, whose powers are suspended. But those powers, which are basically director operations, that means that the person is a director also looking after the operations. Director marketing, that means that the person is a director also looking after marketing. Director finance, that means the person is a director and also looking after finance. So his powers as a director is suspended, and the RP can still give them the powers for operations, for marketing, for finance. And then those assets can be handed over back to them, and that possession should be taken. Yes, I am holding the car of the company, and I have identified the car was visible, and I have handed over the car to this person. I have handed over the other operational assets, machines, stocks to this person. I have handed over the records of the company to this person. However, I can take backup. I can take the SAP backup. I can take the Tally backup. But I can say that yes, I have taken the backup, but I have handed over the uh, records, Tally, SAP to the CFO. So this kind of documents, although these are two words, but this is a very large exercise which IBBI is expecting from us. Very large. That each and every asset that we have to take control, that has to be backed by a list. And these are the lists finally. I'm coming to scenario 2, step 2, step 3, step 4. This is very important to understand what exactly IBBI wants us to do to finally crystallize the total conversations between the corporate debtor and the RP. And also, who is the person responsible who has taken the custody of the assets? Is he taking salary from the company? If yes, then of course he has to be responsible. So this is the scenario one, when the corporate debtor is cooperating. So these documents are supposed to be made. Now let us understand this scenario two, where any asset or record has not been handed over by the corporate debtor, or the list has not been provided. Now there are two scenarios. One, that the corporate debtor is handing over to you by way of a list. And the second scenario is that there is nobody and the RP goes there and take the custody automatically of its own. Then it is the duty of the RP to make. So one, that there is no cooperation. RP is taking some of the information, some of the assets in a different process, which may be under regulation 30, or it may be just by going and taking control and custody, locking the premises and taking the possession. In that case, the RP is also supposed to make a list of assets and records while taking control and custody of the assets and record. Each list of assets and records, each list of assets and record under scenario 1 and 2, both, even if there is a corporation, even if there is no corporation, shall be signed by the parties present. The person who is handing over, the person who is taking over, the team member of the RP, the team member of the corporate debtor. They have to be signing that particular document. Then, by at least two individuals who have witnessed the act of taking over the control and custody, and those individuals have to be independent. Just like a panchnama, just like a panchnama that we make in SARFAESI, just like a panchnama what is made in the income tax searches. So that kind of panchnama document would be made where the each list of assets and records that would be signed by the handing over person or taking over person, and also two witnesses, independent witnesses. So this document is also required to be made in case the IRP is not getting any cooperation and there is nobody who is preparing a list from the corporate debtor side. So the RP has to make this list. After taking the control and custody in this manner, in scenario 2, as a step 2, then again he will have to hand over the possession to someone. In case there is nobody to take possession, then the RP will say that the possession is with me, or is with me, with my team. Or the RP can say that the possession is now with me, however, I have deputed some of the security guards. So this is a very, very important process which has been now inserted in the regulation, which was not there. Always it was a confusion. The corporate debtor was always saying that we have given, and the RP was saying that we have not received. And in some of the emails even used to be missed by the RP or RP's team. So the information, maybe after some time, the RP also used to realize, yes, some information came, I couldn't see that. Now these kind of documents will be made, although it is only a few line regulation, but it actually defines a process which is a very, very important process, and we've been doing it for the last more than 20 years for the SARFAESI actions. Now is this step 3. We have seen step 1, where whatever information is given by the corporate debtor voluntarily with a list. Second, whatever information or the custody or the control of the assets have been taken over by the RP in other manners. We have seen both the lists. We have seen a panchnama kind of a document. Now the third is whatever information is not available as required under section 18A, 18F, and regulation 36, that will be sent to the corporate debtor as a requisition. As a requisition from the RP or the IRP. Yes, I understand from the balance sheet that you have these assets. I understand from the public domain that you have these assets. I understand from an information from the sundry creditors, from the creditors, from the claims that you have this asset. So all this requisition has to be sent to them. Maybe one requisition, maybe 20 requisitions. Because as and when RP gets information through the claims, through interaction with the creditors, through interaction with the committee, through interaction with the employees, any other information, the RP will keep on sending requisitions. It can be one, it can be 20 requisitions at different times. Now, the requisition is sent, and the information that is required by the RP, that is as per section 18, clause A, clause F, and also regulation 36. Now, let us understand what is the step 4. Ultimately, what is the objective of all this? When we file an application under section 19(2), under regulation 30, or under section 68, or under section 70, then in that case, we first of all have to present the presence of such assets or record in the notice of requisition. We have to justify to the adjudicating authority that these assets are there. This information is there. This information is supposed to be there as per this law, but they are not providing me. Either they should say that I have not maintained, or they should provide it to me. Second, absence of such assets or records in the lists made by the corporate debtor or made by the RP. So two things. One, that the assets are present, my lord. This information is present, my lord. Second, all these lists, whatever has been prepared, this asset and this list, this information is not there in these lists. So that is what I require now. That is why I'm actually filing an application under Section 19, subsection 2. That is why I am approaching the district authorities under Regulation 30. That is why I am approaching Section 68 and 70 for prosecuting the corporate debtor personas, because they have not handed over these things which are available but which are not there in the list provided to me. Ankit, I think I'm able to explain it to see this scenario. Ankit, are you there?
Yes, very much. So we can take some questions at this time. I also need a feedback on the chat box if everyone can see the screen properly. I can see the screen properly, but I have received feedback from one or two viewers that they are seeing a cut screen. They're not seeing the full page. So if anyone else is also not able to see the full page, please do let us know. I can take the questions that we have here. Some very, very interesting questions from the practical experience of all our listeners. One of the questions that is here is that, sir, how can an RP find out the assets not handed over considering lack of cooperation from CD and information flow? So I believe here the information that is publicly available in that case is the only way that you can find out about assets. Publicly available information can be whatever information is available on MCA, whatever information is available on the income tax portal, maybe the tax audit reports filed by the assessee or the CD that can have some list of additions. There might be certain fixed assets or inventories or other assets showing up in the balance sheet. That is what comes to my mind. Anything that you want to add to this list of what can be available publicly where the
No,
CD is not cooperating?
I already said, and I'm on the same screen. First of all, we have to justify that these information, these assets, and these records are available. And available means ki, like, we have to say, like, see, if I'm saying that I need the possession of that vessel, possession of that ship, I have to present something that I have information that there is a ship which is owned by this company. So I'm not getting that control. So first of all, there must be some belief that the assets or information or records are required to be maintained and are available with the company. I should first of all be able to justify this before the adjudicating authority. And that can be through, as Ankit, you rightly said, I can only add few more things, like through the information that we get from the claim forms,
Hmm.
the interaction with any of the other employees, by visiting the offices, by looking into some of the records. So this, first of all, there must be a belief with the RP, or has been prepared by the CD, that this kind of record or this kind of asset or this kind of asset or this kind of information should be available. Then he has to justify to the adjudicating authority that he specifically sent a requisition for this. Third thing that he has to say, that all these lists, whatever has been prepared, this particular requisition items are not there in the list. That is what is a valid 19.2 application now. If the 19.2 application is submitted without anything like this, now without anything like this means step one, voluntarily submitted information and records and asset. Step 2, taken by the RP by any other means, forcefully or with the help of district authorities. 3, sent requisitions for the balance information. And while sending the requisition for the balance information, the RP must write that I understand from some records, from some information, that you have this record, information, or asset. That's the requisition. And the fourth document is that whatever list that has been made by the RP or has been prepared by the CD, that particular information, record, or asset is not there. So I think what I'm trying to say, that handing over of the asset to someone, that is a very, very important part in these regulations, that we actually have to say that this particular car was taken custody and control, but it was handed over to the general manager of the company. And that general manager should also acknowledge, yes, I'm using the car of the company, but it belongs to the company and I will keep it safe with me. So very big process now. It is the when you become an insolvency, when you become an IRP for a company, so this particular
I think, yeah, yeah, we lost you. So you're back.
okay. So now, so
You can
Ankit,
share your screen again.
oh, okay. Is it okay now?
Yep. You can make it full screen.
It is okay. So any feedback from the audience whether they are able to see the screen?
Mm, yeah, they were able to see the screen perfectly fine.
So this part of the amendment is very very uh, uh, time. It's a, rather one thing I would say that this process should have been there right from the beginning. This process was not there for 7 years. The adjudicating authority was burdened. The adjudicating authorities, various benches, they were very very aggressive on the RPs and the IRPs. They were not liking this application under section 19.2, and the reason for not liking only was because there was no clarity. Both sides were saying that we have given, the other side was saying that we have not received. So because of this scenario, the adjudicating authority was furious on the resolution professionals. So now, in case we do the work as per this particular regulation, I think it will be a crystal clear scenario that 19.2 will be worthwhile, regulation 30 would be worthwhile, section 68 application, section 70 application will be worthwhile. So this is what I'm trying to say, that this is something which is the most important change in this regulation, which should have been right from the beginning. Can we can we go forward, or should we take some questions?
I think you have clarified this. If there is any unique question, I will ask. One practical question that has come in from that, who should likely be the witness with respect to taking this panchnama? Should it be, an employee who is working there, who is CD's employee? Who would count as an independent witness? Because sometimes these are deserted places. So, what is your opinion there? Who can be this
See,
independent
like when
witness?
see when we were practicing income tax, see, like whenever there is a search, there are supposed to be independent witnesses.
Hmm.
Now there are a lot of judgments regarding independent witnesses, that can a rickshawala standing outside be a witness or not. So these people are supposed to be independent people. One, that I think that they should not be employee of the RP. They should not be the employee of the corporate debtor. They should be independent, other than the directors and employees from both sides. So these people should be independent. So who can be these independent people? Because in this process, I think we can see, if nobody is available, then of course we can have some independent lawyers. Like see some people who actually are providing legal support to the RP. They can also be part of the witnesses. And
Hmm.
on the other hand, in case there are some lawyers or some consultants of the corporate debtor, they can also be independent. One of the independent witnesses. But
Right.
yes, it's a difficult one to find an independent. And if we are not able to find an independent person, then maybe the employee of the corporate debtor can be. But then the employee of the corporate debtor is basically part of the corporate debtor, handing over. The person
Hmm.
who is handing over the information or the asset to us cannot become an independent witness. So difficulty to find practically, but then each situation will be handled differently. Like the person has to be there, and I would prefer that when this particular document is being signed, there should be some photography also should be kept in record. I would suggest, because
My
see,
thought process here is that in case the management is not cooperating, and in case, at the time of visit to the premises, one finds the premises to be perfect, to be completely locked, and then one is taking possession of the premises in that scenario, there would be maybe somebody who has been, keeping that. There might be some security guard, there might be somebody available there. So if that person's status is recorded and then, the witnessing is done, then it will be maybe a safeguard for the RP, that yes, somebody who was having some kind of a control over the CD has also witnessed that the RP was able to find only these assets at the premises. That I think can be a good idea. Apart from that, there might be some neighboring factories, neighboring, people around the place who can act as independent witnesses as well.
But Ankit, this is a very, very big responsibilities on the IRP and RP. I tell you, the corporate debtor will always say that I have handed over the entire inventory, I have handed over the entire plant and machinery, I have handed over the everything, all consumable stores to the RP when the CIRP commenced. Now, how the RP will verify it, how it will be witnessed, how it will be photographed, how it will be videographed. Now, the responsibility that the corporate debtor will always say that I hand it over.
Hmm.
Then, and as on that date, what was the inventory? Because see, he will take out a list from the books of account. I'm talking about a little large organization, and that list of stock may have something like 50 crores of stock, and physically it may not be even 5 crores. He will take out a list from the inventory software, and he will say that this is the inventory that I'm handing over to you, and you sign it. And the RP will say that I have to verify it. He says that I am handing over to you. You sign it. I have signed it. No, you sign it or you don't sign it. I have a copy that I have handed over to you, or you give me a signature that you have received this list from me. Now it becomes the duty of the IRP to see the verify the physical verification of all these items, plant, machinery, consumable stores, computers, furniture, fixture, air conditioners. So like this is a very very big responsibility that the acknowledgement has to be given immediately along with the independent the witnesses. Very big thing to take custody control of the assets and the information, and then and then sending requisitions, and then only your 192 would be admittable. Otherwise 192 will be rejected. So this is a very big change which we are actually I have not seen much of the hue and cry about this. I have not seen any kind of uh, uh, discussions or deliberations happening on this. People are taking this as a very very casually. I'm saying this is not something that we should take up casually. Now, coming to the submission of proof of claims, Ankit, the responsibility of the RP is further increased. Earlier, it was 90 days, and after that, the RP can safely reject and then let the adjudicating authority handle it. But now, the creditor shall submit the claim with a proof on or before the last date of mention in the public announcement, which is 14 days. The provided that a creditor who fails to submit claims with proof within the time stipulated in the public announcement may submit his claim with proof to IRP or the RP 1 up to the date of issue of RFRP under Regulation 36B, or 90 days from the insolvency commencement date, whichever is later. Whichever is later. Now, let us understand that the CIRP starts and there is something that there is some stay for some time, then the process again starts. Then again, there is a first EOI, and then there is a second EOI. So then might be in some cases there is a third EOI after taking permission, after taking approval from the adjudicating authority. So up to the issue of the RFRP, the last RFRP, not the first one, up to the issue of RFRP under Regulation 36B. Because see, any RFRP that we issue, that will be under Section 36 capital B. So that means that even if it is the first modification, second modification, whenever there is an EOI, the RFRP has to be issued. RFRP has to be issued for each expression of interest process. So therefore, it will go till the last issue of RFRP. Now it is not final here. These are where the RP has to verify the claims and RP has to admit or reject the claim, and that too with reasons for rejecting. Now the regulation 12 further says, provided further that the creditor shall provide reasons for delay in submitting the claim beyond the period of 90 days. The reasons, of course, little bit of more work by them, but then yes, even if there is no reason, even if there is no reason provided by the creditor, can the RP reject that he has not provided reasons? Because the RP's obligation is separate. RP's obligation is like 36B. 36B is basically 5 days from the date of issue of final list of PRAs, along with when the information memorandum, evaluation matrix, and RFRP is issued. That is something where we actually have to say up to the date of issue. So that is within 5 days from the date of issue of the final list. So release of EOI, time given for submission of EOI, then for the provisional list, then verification 29A, then final list. Now, up to the final list, the claims has to be admitted or rejected by the RP without anything. Now, in case there are some people, they are not able to submit even up to the issue of RFRP under Regulation 36B, again there is a solution for them. Now, the solution for them is that first of all, the RP or the RP does not collate a claim after verification. He has to provide reasons for the claim. See, most of the RPs I have seen, they in fact they were keeping the claims under verification for huge, sometimes for a larger period. That is checked here, that the RP has to provide reasons for not collating the claim after verification. The RP has to reject or RP has to accept. RP has to collate the claim. Now, the other thing is, in the event that the claims are received after the period specified under sub-regulation 1. Now, what is the period mentioned in the sub-regulation 1? That is issue of RFRP or 90 days, whichever is later. In that regulation 1, in case somebody is not able to submit the claim even up to the issue of RFRP, then this is a solution. What is the solution now? The claimant can still submit a claim up to 7 days before the date of meeting of the COC for voting on the resolution plan. Now, the resolution plans has been received. There are multiple meetings for the deliberations on the resolution plan, and finally, there is a last meeting which actually which will be followed by the voting. Even up to that particular meeting, the claims can be submitted. And RP is required to do that within 7 days, the claim verification, categorizing them as acceptable, non-acceptable, then intimate the creditor within 7 days regarding the categorization, regarding the acceptance, regarding the rejection, and also provide the reasons why the categorization has been done as acceptable or as not acceptable, and also put up all those claims before the COC in the next meeting. And it, along with the recommendations of the RP, based on the documents, based on the verification, that whether they should be included in the list of creditors or not. And those particular report of the RP, after taking the concurrence of the COC, will be presented before the adjudicating authority by the RP. So that means all those claims, all those claims, the litigation regarding claim has actually been shifted to the RP. Litigation regarding claims have been shifted to the RP now. It was earlier with the claimant, now it is shifted to the RP. If there are 20 claims which the RP has rejected, all those 20 claims, they will again say that they will say that this application has to be submitted by the RP to the adjudicating authority for final adjudication. So there is one confusion, Ankit. I'm still confused. If a claim is received, say, much before the issue of RFRP and RP rejects that, then the claimant will file an application against the rejection.
Yeah.
But in case the claim is filed, say at the last moment, then RP will file an application. I think some confusion is there here, because see, this particular regulation 1B, which is inserted, this says that up to 7 days before the date of meeting of the COC, um, all the claims, but then there are many claims which has been rejected by the RP before that. Is it
So,
applicable?
so
Is it
I think,
applicable only
I
to this
think,
part? Yes, please.
I understand that the claim received up to 90 days, the RP is anyways required to consider them under the provisions, and he's supposed to say yes or no after verification of the claims. That's one part to it. Then, starting from 90 days from the CRP date till 7 days before the resolution plan being presented in the COC, till that date, the claims received by the RP is supposed to collate all the claims and put them before the NCLT, asking them to adjudicate on the same. At the same time, I believe the amendment had already come before that the IM that is required to be prepared, based on which the resolution plan is prepared by the PRAs, that anyways has to have all the claims that have been received by the RP, whether they have been received up to 90 days or later. So by the time supposed to prepare the IM, he's supposed to include all the claims, even if those claims have not been accepted by him due to late filing of the claims. So this way, the objective is, I guess, to minimize the adjudication on, the late filing of claims by by adjudicating authority. And adjudicating authority then can only process one application where the RP has himself summarized the reasons mentioned by the claimants as the reason for late filing of claim. And based on
Mm.
that, NCLT can take a decision which ones to allow, which ones not to allow.
No, there are two things, Ankit. One is the rejection because of the delayed filing.
Mhm.
Other is the rejection because of the verification part of it. Now, in case the RP rejects a particular claim, say within 60 days of the commencement of CIRP, then the claimant will go to adjudicating authority and file an appeal.
Yes.
And in case the all those people who are actually filed after this issue of RFRP, it is only for those claimants who have filed their claims after the issue of RFRP, then those claims will go to COC, and after that it will go to adjudicating authority. It will be sent to the adjudicating authority by the RP.
Hmm.
However, the claims before the issue of RFRP, those are a normal, but then the rejection is appealable. Any rejection by the RP, that the claimant will go and file an appeal, not because of the delay, but because of other reasons. So we are actually targeting two separate things, Ankit. One is uh, the issue of belated claims, and the
Yes.
other is the wrong claims. As far as the wrong claims are concerned, the wrong claims, there is no change in that process. Belated claim, this entire process actually is applicable on belated claims. It is not applicable on the otherwise incorrect claims. Is that correctly? Can we conclude correctly like
Yes,
this?
I am totally with you that this is what I was rather trying to say, and I think you've clarified that like anything that this is not for rejected claims, this is for late claims.
This is late. This process is only for delayed claims, belated claims. Right. So then I think we can go forward. Verification of claim is handled. I mean, this is one important part is that it is only for the class of creditor that now there is a power of the class of creditors to replace an authorized representative, and the this in regulation 16 capital A sub regulation 3 capital A has been inserted, and the in this case the process that has been defined is that at least 10% of the voting share of the class of creditors they should actually make an application to the RP for seeking replacement of the AR. Uh, then they also have to propose an insolvency professional of their choice, and then by making a request to IRP the RP, who shall circulate such request to the creditors in that class. Now, in the RP will circulate after seeing three things. One, that the request representation has been made at least by not less than 10% of the voting share. No, the voting share is within the class of creditor, or voting share is uh, within the overall committee of creditors. That has to be seen. But my understanding is that this less than 10, not less than 10% is basically voting share of the overall COC. It is not between the class of creditor. Representing not less than 10% of the voting share is total overall COC. Then is the RP will circulate such request to the creditors in that class, and then will announce a voting. And the announce a voting open for at least 24 hours. But then what is important here is the when this voting will start, the RP will again have at least three insolvency professionals to the financial creditors of their choice. Now, in that three, the existing AR will also be there. So one is the person proposed by them. There may be another person who is proposed by another person. There may be a person who is proposed by another person. If there is only one proposed by that class of creditors, then the RP will add two more. Then the RP will add two more, and then the fourth one would be the existing one. Then the voting will start, and finally, the RP will make an application to adjudicating authority for selecting that particular authorized representative who has got the maximum voting in his favor. So this is also something which is not very clearly mentioned, although it is mentioned that the existing will also be added. So I could understand that it is 3 plus existing which will go for voting. The fee for the authorized representative have been increased. It has been doubled. From 15 it has been made 30, from 20 it has been made 40, for 25 to 50 for each meeting. And then now the authorized representative job has also become lucrative. For each COC meeting, there are two meetings with the class of creditors is admitted. One may be before the COC, one may be after the COC. So there is a fee of 10,000, 12,000, 15,000 is also permitted. Now let us understand, for one COC meeting where the total class of creditor claims are more than 1,000 rupees, first fee that the AR will get is 50,000 rupees. Then the ARP will get 15 into 2, 30,000 rupees from the meetings with the meetings with the class of creditors. So it becomes 50 plus 30, 50 plus 30, it becomes 80. And also, any additional meeting can also be approved by the committee of creditors. So in one or more two meetings are admitted, so the AR will get about a lakh of rupees where some claims of more than 1,000 home buyers or debenture holders or depositors are there. So this also has become a lucrative compared to the fee of the RP, which is much reduced now. So the ARs also, the P fee will be CIRP cost. The beyond two meetings, for some further meetings can also take place with the approval of the COC. And also the additional scope of work has been given. Now, the additional scope of work, when we say additional scope of work, this is all kind of like assisting the creditors in class. He represents in understanding the discussions and considerations of the committee meetings and facilitate informed decision making, review the contents of minutes prepared by the RP and provide his comments on to the RP, help the creditors in a class he represents during the consultation made by the RP to prepare a strategy for marketing of the assets of the corporate debtor, work in collaboration with the creditors in a class he represents to enhance the marketability of the assets, assist the creditors in a class he represents in evaluating the resolution plans submitted by the RAs, ensure that the creditors in a class he represents have access to any information or documents required, then like update regularly the creditors in a class he represents on the progress of the corporate insolvency resolution process, make suggestions for modifications in the resolution plan, record proceedings and prepare minutes of the meeting with the creditors in a class, act as a representative for the, see, like this is an additional, the J is like simple, the J is very important. Now the AR is also authorized to file applications on behalf of the class of creditors. So before the adjudicating authority, appellate authority, or any other regulatory authorities might RERA, etc. So this additional scope of work is also important for the authorized representative. So the time is actually passing on because I wanted to explain. See, this is only a little bit of anomaly because see, when the debt is getting transferred, I'm not talking about the regulation 28. When the debt is being transferred during CIRP, so there was no timeline. The timeline was only for the RP, but there was no timeline for the assigner and the assignee. Now there is a timeline of 7 days for the assignee and the assigner during CIRP that they have to inform the RP, and then the RP will notify the adjudicating authority of any resultant change in the committee within 2 days. That is only one anomaly that has been corrected. Audit of the corporate data. This is opening up another. So the two opportunities have now opened up. One to become AR, which has become uh, a little less risk, a little less responsibility, and almost a very handsome fee in case there are one meeting, in case there are 15, 20 meetings in a PTC or CIRP period. I think the in case there are two meetings in a month, I think the AR will make more money than the RP. Without any responsibility, AR will make more money than the RP. So uh, like the as far as the class of creditors are concerned, the class of creditors can be a different kind of class of creditors, but the AR assignment is very, very important now. It is lucrative with lower risk, and the you would see some cases the fee of the AR will be more than the fee of the RP. Now, coming to the audit of the corporate data. Now, when I say the audit of the corporate data, this actually means that the audit of the RP. So, this actually means the audit of the RP. So, any member of the COC may propose the audit of the corporate data along with the objective scopes, estimate of the cost, time frame, and the proposed auditor. 33% voting share is required for making such proposal, and the audit can be conducted if it is approved by the committee of creditors. Because this is an operational matter, so it doesn't require 66% voting, it requires only plus 50% plus voting. Audit shall be conducted by an insolvency professional having the qualification for such audit. If it is a financial audit, then it will be a chartered accountant. If it will be a cost audit, it will be a cost accountant. If it will be secretarial audit, it will be a secretary. So the audit of the corporate debtor can be appointed. It is not simply a chartered accountant, but anyone who is qualified to do that audit. Along with that, he should be an insolvency professional. So these auditors can be appointed by the committee. The auditor shall prepare a report detailing his findings, and the same shall be presented before the COC. The expenses of such audit shall be treated as CIRP cost. Now, but the question is, when we do the audit, the requirement is that the person should also understand the IBC. He should be an insolvency professional. He should also be a chartered accountant in case it is a financial audit. This is a different audit, but this doesn't take away the main position of the statutory auditor, the main position of the tax auditor. Those two things are totally separate. This is a audit of the corporate debtor for the process. It can be audit of the operations also. It can be audit of the CIRP cost also. It can be audit of the because see, presently it is the CIRP regulations. I'm not sure whether it is applicable to the liquidation cost during liquidation, but as of now, the power to appoint auditor, according to my understanding, is only during CIRP and it is not during the liquidation. In liquidation, this regulation 30B would not be applicable. So it is only during CIRP when they can also say that we are not interested in auditing the operations. We are only interested in auditing the CIRP cost. So that also can be the scope. In some cases, the committee may say that we are only interested in the audit of the operations with a specific objective, with a specific scope. Maybe in some cases, the COC may say that if you are conducting a CIRP process and you are in operations, you have a textile factory. So we want to understand at what price the raw material is being purchased and at what price it is being sold. So that audit, a specific audit with specific scope, can also be appointed by the auditor. Some committees may say that we understand the operations and but however we want to appoint an auditor for the CIRP cost. So this is also a kind of opportunity. Anyone who is an insolvency professional as well as the chartered accountant, after this particular regulation, I believe within another 6 months' time, in most of the CIRP cases, the auditor would be appointed. In most of it, because the committee would be very happy to appoint the auditor. Now, the last, yes, Ankit, I think we are already off time. Regulation 36 capital B, it's only like the information memorandum valuation metrics and the RFRP has to be shared with the after the final list of PRAs is released. Earlier, it was only the provisional list. Now it is made the final list and on the final list. Now I am actually giving this a revised timeline. So this is the revised timeline for any expression of interest. But then one thing that we have to assume that when we are saying that the submission of EOI, in that case, section 36, in the regulation 36A says that the 15 days is the minimum time. But then we've seen that the most of the time the 30 days are given. So in case 30 days are given, when we can actually complete a process by 120 days, and in another case we can finish a process in 105 days. However, the submission of information memorandum to COC, there is no change, that is only 95 days. So there is a modification in Form G, and in the Form G, what they have proposed is that most of the financial information that will be there on a link. In Form G, there will be a link. So before you issue even the Form G, the link would be there, because everyone has given a feedback that Form G, when Form G is issued, there is nothing available with the prospective resolution applicants. Now they are saying that the information, detailed Form G, that should be there on a link, and once you click that link, it should be the all this information, financial information, should be visible to everyone. Similarly, Form H has been modified regarding the minutes of the meeting where the resolution plan was considered, that has to be attached along with Form H as an annexure. I think I have finished this part, Ankit. I can stop sharing for some time.
Just two quick questions before we stop for the day. One is that with respect to the AR change, the question is that if the AR, the class of creditors together comprise, say, less than 10% of the total voting power in the entire CD's case, then what will be the requirement for change of AR? If the total percentage held by a class of creditors and the overall voting share in a COC is in itself less than 10%.
That's what I understand. In case the total is less than 10, I believe maybe that the power to change may not be there. I will still check that, but then I still feel that it may not be there, Ankit. But
Hmm.
let's see that. Let me even go through the regulations again, since we have now this question. I'm actually coming to this. Let me take out these CIRP regulations, and let me go to the. So what is this regulation? So now they are saying that this change is there. The financial creditor in a class representing not less than 10% voting share, the financial creditors in a class representing not less than 10% voting share may seek replacement of the authorized secretary. I think this is the any if the total financial creditors are having less than 10%, they don't have any requirement of changing.
Hmm. Okay.
This is financial creditor in the class representing not less than 10% voting share may seek replacement of the authorized with the insolvency of their choice. I believe this 10% is to for the it is referring to the total voting share of the committee of creditors, and not the class of creditor, because it should have been mentioned that it is 10% of the class of creditor, but they have not mentioned that.
So if
So
they've
it is,
not mentioned it, we should assume that it is the entire COC.
yeah, it is. We assume that it is for the entire COC.
Right. So then, of course, the second question that is required is that when this collation of belated claims is required to be made by the RP before the NCLT, at that point in time, does the RP also verify or look into the verification of those claims before filing that application, or he simply asks the NCLT if should consider verifying these claims,
The
belated
verification
claims?
is very important. Without verification, you can't even take up the issue of belated claims or timely claims.
So the RP will get
Before,
the claims, he will verify it, and then after verification, he will put that application to NCLT,
yes,
also adding his opinion on the acceptability with respect to the belated nature of with respect to the the acceptability of the claims after
absolutely.
verification.
Absolutely,
Okay.
absolutely.
I think yes, we can have as many questions. So there are many questions today. This is of course a topic which requires, maybe much more time for everyone to understand. And but I think we are already 15 minutes over and above our start time.
Yeah.
So we can wind up for the day. In case there are any further questions, we'll be happy to take that up offline. And thank you to all the attendees and coming to today's webinar in such large numbers.
Thank you very much. Thanks a lot. Thank you very much.
Thank you.
Thank you, Ji.